my lords, my lady. The only bundle I'll refer to this afternoon is the core volume in Willmore. The judgment of Mr. Justice Nicol is to be found in that volume behind tab E. This is part 1.
Well, we don't have tabs, but...
It's part 1, page 15. In relation to the judge's findings, the first submission we make is that the learned judge's findings were not in breach of an agreement between counsel or contrary to a concession that I made. The agreement was that if there was only one occasion when the claimant, Mrs. Willmore, was in close proximity to workmen handling materials containing asbestos, that would not be enough. That was the concession, the agreement.
So, do you disagree with 6.9 of Mr. Stuart Smith's argument at page 35 of his case?
Yes, what I accept is that the claimant's direct evidence, her recollection, was of only one occasion. I accepted that that would not be enough. And it would not be enough for the very good reason that on that evidence alone, the learned judge would not be able to conclude that there had been a significant exposure to asbestos, hence no breach of duty, no causation. If the judge had found that there was only one occasion, but that represented a significant exposure, that would have been contrary to my concession. One sees the point as to how it was put to the learned judge at page 186 in part 1. Letter just above letter B. This is my submission to Mr. Justice Nicol. The finding that the court is invited to make that whilst the claimant only recalled workmen on one occasion, the likelihood is that on a number of occasions she will have walked along this corridor when workmen were working there and were working in relation to the ceiling tiles so as to create significant amounts of dust. It is not, and I emphasise, not part of the agreement that the parties have reached that the claimant has to establish it was a regular occurrence. It was agreed that it would not be sufficient if it was simply the isolated occurrence described by the claimant in her evidence. It did beg the question what would be enough. There wasn't agreement between counsel on that issue. And the difference is highlighted in the judge's judgment. At paragraph 8. Where Mr. Justice Nicol states, quite what would constitute de minimis in this context was the subject of some discussion at the trial. Mr. Allen, Queen's Counsel, on behalf of the claimant, accepted if there had been but a single occasion when the claimant had been in the vicinity of asbestos dust in the school, that would not be enough. However, he contended that not very much more would be needed. He draws attention, and then there's a reference to Dr. Rudd's evidence, and then at the bottom of the page, Mr. Feeney contended that to be more than de minimis, it would be necessary for the claimant to show that she was with some degree of regularity in a situation where she was likely to be in contact with asbestos fibres in the school. I will need to return to this topic. In the event, the judge's finding of fact went beyond the claimant's direct evidence, and his finding of fact is to be found in paragraph 31 of his judgment, which begins, the claimant could only remember one occasion when she passed the workman. And the learned judge makes reference to her written statement where she'd recalled bantering with the workman, and he, that is the learned judge, concluded that she must have encountered them more than once. The claimant said that she used that corridor frequently, and then the learned judge says this: I think that I can infer that the workmen must have been present for some days for their presence to have been remembered by the claimant and Miss Welsh, but whether it was more than a week, the evidence does not allow me to conclude. And then over the page at paragraph 34, one sees the learned judge's conclusion that there was intermittent exposure over the course of a few days. So it is the position that the learned judge drew inferences that went beyond the claimant's direct evidence. Our submission is that he was entitled to do so.
That, it seems to me, is the critical issue between them, because, as I understand it,
It is.
unless we decide that he wasn't entitled to do so, the subsequent reliance on the agreement doesn't arise.
Exactly. I agree. The context, of course, was of a witness, Mrs. Willmore, who the judge found was an honest witness, struggling to recall events some 40 years before. And in drawing the inferences that he did, the learned judge had regard to the entirety of the evidence. And he set that evidence out carefully and analysed that evidence carefully. And that is between paragraphs 12 and 54. And it's not my intention to go through that evidence. But particularly salient points were the construction of the new school, not finished when occupied. There was a good deal of documentary material. This is referred to by the learned judge, paragraphs 16 to 22. The learned judge made a finding of fact that the ceiling tiles in the relevant area contained amosite, brown asbestos. That's not challenged. And then, of course, the judge had regard to the entirety of the oral evidence. In coming to his conclusions on the evidence, the judge rejected some contentions as to exposure. He found others were established. To those findings of exposure, he applied the undisputed medical evidence of Dr. Rudd.
Did he at all, in his reasoning, approach the matter? The claimant contracted mesothelioma, that of itself raises quite a strong inference that she must have been exposed to a significant amount of asbestos somewhere.
It doesn't form part of his explicit reasoning. No, it doesn't, my lord. He approached the assessment of exposure, as he was invited to do, as a matter of impression, and drew his inferences and conclusions accordingly. And as my Lord Phillips has articulated, the crucial issue is whether he was able to draw the inferences that he did. Unless I can assist in respect of any matters, those are the submissions in the case of Willmore.
Thank you very much.
Sorry. I just, I mean, it was justified in using this memorandum 1982, wasn't it? Memorandum.
Yes.
10 years after. I'm just looking at paragraph 33. I mean, because we're talking about an event in 1972, aren't we?
We are, my Lord, because these were events in the early part of the claimant's
The memorandum of
time at the
1982,
school.
paragraph 21, begins, there have been several occasions recently where work has caused and given concern to the safety sector.
We say the conclusion he was entitled to draw from that document is that that document was not describing just a situation that would be arising at that time. Given the history of the construction of the school, the materials that were used, the problems identified in that document are likely to have been going on for a substantial period. And the judge was entitled to draw that conclusion.
Do we have the memorandum?
It's not in the bundle. As your lordship can see, the judge has set out parts of that.
They can't have been cutting asbestos board ceiling tiles for 10 years. I mean, one assumes that maybe after 10 years something would require attention, but as my lord says, what's the position in 1972?
The memorandum refers, I think, to schools in general.
Oh, it is, yes, and
It's not very particular.
It's summarised where, apart from paragraph 33?
21.
21, my lord,
Oh, yes, thank you.
the terms of the memorandum,
Paragraph 21.
parts of it are set out.
And it doesn't refer to this particular school?
It doesn't, no. It's a general memorandum from the defendant authority. The particular relevance that is referred to in paragraph 22 relates to the submission made on behalf of the claimant that the judge could conclude that in the past safe practices hadn't been adopted. Otherwise, this memorandum wouldn't have been necessary. Unless I can assist.
Thank you very much. Mr. Kilvington.
My lords, my lady, I follow.
Yes, Mr. Speaker.
Quite shortly, my lady, my lords, I would like first to deal with 3 points of factual detail to clarify them, if I may. Then to return very briefly to pick up some of the points that have been raised by the court and by my learned friends on material increase in risk in Fairchild. Then briefly to look at Professor Stapleton's article about the impossibility of proof upon which so much weight is placed. Then answer a question asked by my Lord Kerr yesterday about the epidemiological studies that might form the basis for the approach that has been taken in some cases. And then possibly spend about 40 seconds on Willmore. I hope that the entirety of that will not take more than 20 minutes and will not try your patience too much. First, on factual details. Point 1, it is correct that 2 other people who had at some stage been employed at Van Leer's, as Greif were then known, contracted mesothelioma. They were a Mr. Cresswell and a Mr. Hardman. Mr. Cresswell only ever alleged exposure in the course of his employment at Van Leer, Greif. Mr. Hardman alleged exposure in the course of 2 other employments, Camel Laird, as then had been, and AEI, under one or other names. Both those claims concluded in settlements without any issue being taken on the extent of exposure or whether it was material. But the extent of exposure that was alleged and the circumstances in which exposure was alleged in both those cases was very different from the allegations of exposure made by Mrs. Sienkiewicz, who, as you know, was primarily an office worker, which neither of those 2 gentlemen were. That was all I was going to say in relation to that little corner of factual information. Secondly, I do not remember whether it was Mr. Allen or Mr. Melton said this morning that it is generally accepted that the relative potency of the 3 commonly named types of asbestos was in the ratio chrysotile 1, amosite 100, crocidolite 500. On this side, we do not accept that that is a ratio which is generally accepted. It is a ratio which is suggested by one paper which involves a meta-analysis of other papers, Hodgson and Darnton. But it is one of the features of Hodgson and Darnton that it is not generally accepted as a reliable or conclusive or determinative base. The other feature about these ratios is that one should not make the assumption, which is easily made, that the constant between various different assessments is in the 1 for crocidolite. Most people start with 1 for crocidolite and then give for chrysotile and then give an increasing range. But I do not wish to start trying to give expert evidence at this stage, but I would submit that this court should not make the assumption that in different papers, everybody treats chrysotile as being the same and then augments up from there.
But you accept that they are of different potency?
Oh, definitely. And I also accept definitely that they go in ascending order, chrysotile, amosite, crocidolite. But there is no consensus as to the relative potencies. There is some evidence about that in Dr. Jones's report, but I'm not going to trouble you with the detail of it. Thirdly, my learned friend Mr. Allen took you to American authorities this morning, which was fair enough since we had cited those passages from Rutherford in our case. Those authorities and those submissions need to be taken in the context of the 2 fictions that are adopted in American jurisprudence. which, and on this I'm happy to realign myself with Professor Stapleton. She has conveniently set out for you in the other article that you have in the bundles, which is in bundle 2, tab 36.
Do we have a date for this?
Well, it's got to be after 2006 because the latest reference in it is to a 2006.
But, I mean, presumably it's before the earlier one in the bundle. I mean, before the
Yes.
tab 30.
Yes. No. The earlier one is this year.
Yeah.
In the light of your lordship's question, if no one else objects, I will find out overnight and just inform the court of the actual date.
Thank you very much.
But what this she sets out in her typically clear introduction what the article is about. And if you see at the bottom of the page, she says this article is divided into 6 parts. Part 1 describes how in asbestosis cases, US courts absolve plaintiffs from the requirement of proving the portion of the total injury for which each culpable exposer was responsible, and thereby, in effect, proceed on the fiction that asbestosis is an indivisible injury attracting joint and several liability.
I think you see the date actually on the next page at the top. At the top right. It's 2009.
2009. Yes, thank you. Yes. I'm not quite sure how long I spent trying to work out what was staring me in the face. I do apologise. But on the second page, which is page 1002 of the bundle, page 1012 of the report of the article, she then describes the second fiction. Part 4, this is the beginning of this first full paragraph. Part 4 describes a second, far more radical doctrine concerning proof of causation that US courts developed in claims for asbestos-related cancer, whereby a plaintiff is allowed to establish factual causation against a defendant merely by showing that the defendant's tort exposed the plaintiff to a significant amount of asbestos, and therefore to a significant risk of contracting an asbestos-related cancer. In effect, this allows the plaintiff to proceed on the basis that each significant exposure to the risks of asbestos was causally involved in the triggering of the cancer. But it also operates in relation to asbestosis because of the first fiction. And so the effect of these two doctrines, I've been calling them fictions, but of these two doctrines, is to equate asbestosis and mesothelioma when consideration is given. And therefore the fact that you see passages in cases which actually involve asbestosis does not mean that they are irrelevant to cases of mesothelioma. So that is the 3 items of factual clarification that I was going to propose. May I very briefly return to my learned friend Mr. Melton's submissions about whether there is any such thing as a material increase in risk within the Fairchild doctrine. He rested his submissions yesterday on 2 propositions. Firstly, that any exposure in breach of duty gives rise to a material increase in risk. And secondly, that breach of duty is a sufficient control mechanism. And in truth, both of those propositions depend on the first of them, namely that any exposure in breach of duty gives rise to a material increase in risk. And it is entirely circular, because it equates any increase in risk with material increase. And I made my main submissions in opening the appeal and don't wish to repeat them, but we submit that the consequences of defining in advance that any increase is material can be summarized as being 3. First of all, it means there is no concept of de minimis. Precisely because you have defined any exposure in advance as being material. What that means is that any negligent exposure will attract liability at common law because you have defined in advance that it is material. And that, as we know, then leads to 100% responsibility for the mesothelioma. The second concept can be, or the second consequence can be described in two ways. First of all, using the language that Mr. Laleng used in the article that I took you to, it collapses causation into breach. Or to use my Lady Hale's language, it does away with causation altogether. And that is not only true in common law for the reasons that I've given, but it also applies to breach of statutory duty, where, as is common ground, and as the learned judge in Sienkiewicz recorded, the asbestos regulations effectively preclude any exposure. So if you have defined in advance that any exposure is going to be treated as being material, you inevitably have liability as soon as you prove breach. And so, to use Lord Justice Sedley's language, breach leads ineluctably to liability for all consequences of the mesothelioma. And that leads to what we say is the third consequence, which is that breach of duty is not a control mechanism at all in relation to causation, because of this prior definition of materiality. And so what you have here is effectively no test for materiality advanced by the respondents, and a test proposed by the appellants, which we submit does not empty the content of duty or run into any of those sort of objections, because, not least because in the great majority of cases, the question simply is not raised because it is not relevant.
And your test doubles the risk from the environment.
In Fairchild, as a threshold requirement to get into the Fairchild enclave, you should be satisfied that viewed alone, it would have been regarded as either doubling the risk or satisfying causation on normal principles. It's just viewed alone against the background exposure. Then may come a second stage to determine whether it's material within the Fairchild language, which is, I think, all at the bar acknowledge that there could be a case where, despite the fact that it satisfies that threshold requirement, the possibility of it being the cause of the mesothelioma, and therefore material within the language of Fairchild, is swamped, to take the 20 years as a lagger and then a week of light exposure. And so you don't in Fairchild language decide that something is material until you get to the end of that. But what we are offering is a threshold test to decide whether whether an exposure is then to be considered as being material. It doesn't determine that it is, but it, in many cases, probably will prove to be material.
So doubling the risk is only used to see if it's within Fairchild.
Whether it deserves consideration as a Fairchild multiple cause, yes. It doesn't finally answer the question whether or not in Fairchild language it was material, because of the possibility of its contribution being utterly swamped by something else. And that goes back to the submission that we put in our case, which is our understanding is that that is a proposition that Dr. Rudd would accede to, and I think his suggestion is 1%. But that is something that can be worked out on a case-by-case basis. The only other submission I was going to make in relation...
Can we just pause there?
Yes.
If you wait to the end and it's swamped in only 1%, that's one conclusion that you can draw, even if presumably it was 2.5% of ambient exposure.
Yes.
But how about the other way around? You get to the end and there's nothing more at all, and you've got something that has raised exposure by 95% of ambient
Yes.
and mesothelium has been contracted.
Yes. Is this a single exposure case?
Yes.
I have, in a single exposure case, I hope my position clear in opening, that I do not regard 2 as being a precise
Grey
method,
area.
because of the imprecision that there is always likely to be.
Yes.
But the only other point.
Sorry, just before you leave that, would you accept, therefore, that this is really a rule of thumb to be used in order to decide whether it's likely to fulfill the material increase in risk criterion?
But I would seldom describe anything that came from this court as simply being a rule of thumb, my lord.
No, well, it hasn't come from this court yet. It's coming from
No, but I am an eternal optimist, and it is not. If it were to come from this court, I would not describe it as a rule of thumb. What I would describe it would be as guidance, as an appropriate approach to be adopted by trial courts in determining whether or not a particular case or a particular exposure is appropriate to be considered within the Fairchild Doctrine.
Well, whatever the nomenclature, it's a rule which can only operate where you have reliable epidemiological evidence. Is that right?
The precision with which you would apply it would be dependent upon the precision of the evidence. So if a trial judge was satisfied that he had evidence which was absolutely, and this may be unattainable, utterly precise, then the trial judge might be prepared to go very close to a straight mathematical approach.
The obverse of that must be that where you cannot have confidence in the reliability of the epidemiological evidence, then this is a rule that is, at the very least, difficult of application.
I would not accept that it's particularly difficult of application, because I would submit that it becomes part of the standard approach that a trial judge has to take to evidence that is presented to him.
Yes, but if the evidence is not reliable, you're applying the rule to unreliable evidence, that's bound to produce a questionable result, is it not?
It provides a result, or it provides the evidence will be more flexible, or the approach that the judge can take will be more flexible. And my lord, can I come back to the way you first put your question? If I was being asked if what I was proposing was a rule of law or a rule of thumb, I would probably go for the thumb.
Yeah.
But I'm completely lost. I mean, if it's reliable enough to be worthwhile at all, why isn't epidemiological evidence reliable enough actually to meet the whole problem that Fairchild is designed to deal with?
The reason why I'm allowing for a degree of flexibility, my lord, is that I would accept that it is that in cases such as we are likely to be dealing with, where there are difficulties of recollection, there are imprecisions in the precise, or there's a lack of complete precision in what the background will have been. There may be a lack of complete precision as to, or the court may take the view that there's a lack of precision in the absolute measurement of what the tortious exposure was, that it would not be right simply to apply an absolutely straightforward, you get to and you ring the bell. And that's my position.
But could I try another answer for my lord? You've got jolly good epidemiology, and it tells you that there are 3 defendants. And it tells you that one of those 3 defendants undoubtedly caused the mesothelioma. But it also tells you the chances of it being A are 30%, and the chances of being B are 35%, and the chances of it, well, add up to 100 with different percentages for each. But in no individual case can you say it's more likely than not that it was that particular defendant. That's the problem.
My lord, I consider in those.
That is, I mean, if you restrict Fairchild to that, I mean, that is an amazing restriction.
My lord, if you are, my lord's question in the way that I've been putting my submissions carries a latent ambiguity. If you are looking at what I'm called, for these purposes, called the first stage. The question of comparison between the three exposures doesn't arise, because you just look at each exposure as against the background, if it's very light. And this only arises when it's very, very light. If you then have three exposures, which on an epidemiological prediction of risk, someone might say are 33, 35, and whatever is left, 32. I understand we are then in classic Fairchild territory, where the position is that you simply cannot choose between those three, and those three would all be held liable in solidum because of Section 3. And so my Lord's example, which is clearly addressing a Fairchild case, that the percentages are not something which is in issue in this appeal.
No.
Because by the time you get to the percentages, you're in Fairchild.
Yes. Now, I was just seeking to give the answer to my Lord, who was saying if epidemiology can really give you a percentage, why do you need Fairchild? And the answer is because it's very unfair if you've got three potential tortfeasors, but the miserable claimant cannot identify which, on balance of probability, was the one.
But what about the claimant who can show that doing a complicated fibre per milli, whatever it is, per hour calculation, one particular defendant is responsible for 80%, and there are two others, each responsible for 10%.
Then you don't need Fairchild.
Well, that's your submission, that you don't need...
My submission is that on the present understanding, until someone comes along and challenges the whole factual premise on which Fairchild is built, my understanding would be that if you had three exposers within the Fairchild enclave, i.e. they've passed my test or whatever test may be, that is classic Fairchild. They are all liable. Each of them is liable up to for 100%.
So you
because you simply cannot, even on 80-10-10.
We'll come back to my Lord's question then, though. If it's possible to, impossible to allocate in that case, or to take a less extreme case, a case of 60-20-20, why is it possible to allocate in the present case, where it's...
Which on Tuesday I confessed to being unable to give a satisfactory scientific answer to, but that is, we say, the position.
But you find yourself with the classic Fairchild difficulty, because all you've got to go on is epidemiology. Whereas if you had more to go on by way of scientific explanation, you would then have material which would enable you to distinguish on balance of probability which of the three potential tortfeasors was the one who was actually responsible, because it's in the first 5 years that it really matters, or the last 5 years, or whatever.
It may be that medical science will evolve so that so far as mesothelioma is concerned, Fairchild becomes redundant. On the other hand, the principles that the court has laid down in Fairchild and Barker will then continue to be there and applicable to some other disease where the same considerations apply, if that happens. But as was noted in Fairchild, we don't know yet, but we may.
But before Fairchild, one would expect there to have been cases where defendant A had employed the claimant for 80% of the time and defendant B for only 20%, and there was an issue as to whether defendant A shouldered all the liability on balance of probability. We haven't been referred to any such cases.
I am not aware of any case with mesothelioma where, with multiple tortfeasors or multiple negligent exposures, someone fought and either won or lost a case that they should be excluded because their contribution was minimal.
Or because somebody else's contribution was on balance of probability the dominant.
Swamped the combination.
Yes.
I'm not aware of that. What was very common was that a lagger or someone who worked in a trade that was dangerous because of exposure to asbestos worked for a number of different employers. And routinely, how that was dealt with was by being carved up between the defendants, typically on a time-on-risk basis. and until someone took the Fairchild point. And then we know what has happened since then. That brings me to, if I may then leave material increase in risk and come to the argument that was based almost entirely upon Professor Stapleton's paper. Can I, namely that it's impossible to prove on conventional principles, can I once finally take you to that, which is in bundle 2 at tab 35? And this argument, apart from being based on page 354 of the, and 355 of the Stapleton paper, is based on two propositions which Professor Stapleton espouses. One, there may be a threshold, and two, risk may not be proportionate. What is quite clear, if one looks at the first paragraph on page 354, is that Professor Stapleton accepts the possibility of proof on normal principles in a single exposure case, because her first sentence says that in a few contexts this evidentiary gap need not present a barrier to the victim's claim if the court accepts that mesothelioma is a signature disease of asbestos, that is, can only be caused by asbestos. If the victim can establish that the defendant was legally responsible for all the asbestos exposure of the victim, factual causation can be established on orthodox principles.
That would seem to exclude ambient exposure altogether.
Professor Stapleton knows very well about ambient exposure because, if I may be so unkind as to suggest, that when one sees in the next paragraph that she has adopted 0.18 and 1%, Professor Stapleton doesn't do something like that without a reason. And the ratios in Sienkiewicz were 1 and 0.18. And this is an article which is undoubtedly written with Sienkiewicz in mind, and indeed Sienkiewicz is expressly mentioned. So that is the first oddity about this, from which I would deduce that the assertion of impossibility of application of doubling the risk approach can only apply to multiple exposure cases, whatever the logic. And as was picked up, I think, this morning, or possibly yesterday afternoon, in her review of the Australian approach on page 355, while pointing to the position in New South Wales, she also notes that in Western Australia, 2 lines from the bottom, Western Australia has adopted expert evidence of estimates from fibre contributions and so on and so forth.
Sorry, I think I missed the last point. What was it that you derived from those two passages?
Well, from the first passage, the passage at the top of page 354,
yes,
is the possibility of assessing, proving on normal principles causation in what I call a single exposure case.
Sorry, you derived that possibility? Or
if the victim can establish that the defendant was legally responsible for all the asbestos exposure of the victim, factual.
Yes.
Yes. The other point to note from the text of this report is that in her review of the various Australian approaches in the second half of page 355, having noted that Australia hasn't adopted Fairchild and that the New South Wales approach is, as read to you, I think, by Mr. Allen this morning, which is a sort of Bonington approach, assuming that every exposure contributes to the triggering. At the 2 lines from the bottom, for example, in Amarca, Parity and Moss, which is not the Amarca case that I referred to yesterday, the majority of the Supreme Court of Western Australia rejected such a low-dose claim on the basis inter alia of expert evidence and so on. So that is really my first submission on Stapleton, that it accepts the possibility of proof. But the second submission I make is that, as you have seen, and as was elaborated yesterday, it rests on two propositions. First, that there may be a threshold, and secondly, that risk may not be proportionate. But the evidence before you, which you were shown some of by Mr. Allen this morning, is from Dr. Rudd, page 62 of the Willmore appendix, which is that there is no known threshold and that risk is proportionate.
I'm sorry, no known threshold doesn't mean there isn't a threshold.
No, but it's gone so low and no threshold has yet been identified.
You said gone so low. I mean, it might have gone so high.
No, well, that isn't what it means because the fundamental assumption is that every exposure contributes to risk. Mesothelioma can occur after low-level asbestos exposure, and there is no threshold dose of asbestos below which there is no risk. However, the risk that mesothelioma will occur increases in proportion to the dose of asbestos. And that's on page 62.
Well, we looked at that earlier. I mean,
You
I
did.
suggested he wasn't meaning in direct proportion. Do you suggest that means in direct proportion?
I accept that there are variants to be brought in by the toxicity of the particular substance, but I do understand him to mean in direct proportion. So that if, for example, someone were only exposed to chrysotile, the increase in risk would be in direct proportion to the exposure to chrysotile.
How about the time element? Is that potentially relevant? Can you compare two exposures of precisely the same volume, if that's the right term, but one exposed in the course of a week and the other exposed in the course of a year?
The fact that one is on a week, but to make it slightly easier, a month or a year,
Yes.
is not of itself, has one significance, which is that exposure is evened out. So to take the example that was given to you yesterday, that the momentary exposure that Mrs. Sienkiewicz was exposed to would then be regarded, would not be, the fact that it was more intense over a short period would not of itself be regarded as being of critical importance, because you look at the dose averaged out over time. The second question
Is that based on epidemiological result or seat of the pants?
I believe, well, it is a position which is accepted by epidemiologists, I think is as far as I can go.
Yes.
Whether it's the epidemiologists working by the seat of their pants is not something that I'm able to answer.
Yeah. I mean, sometimes one has to proceed on a thesis until the opposite is proved.
Yes, but time is undoubtedly of significance and has been seen to be of significance because, for example, the model which Dr. Jones and the IOM have adopted, which they regard as fitting the data best, attributes a time cubed to distance of time rather than the duration of the exposure. So an exposure 40 years ago has had 40 years to operate upon the physiology of the, if that's the right word, of the individual. And so in that sense, undoubtedly time matters. But whether a dose was given over a day or a week, as far as I am aware, does not.
Apparently age may matter, but according to looking at Peto, but I mean that's difficult to detach from the duration of development of the malignancy.
It is.
Because
If it's developed for a long time, you're quite old.
quite.
I made inquiries after, I think, questions which my Lord asked this morning as to whether there has been epidemiological inquiry specifically targeting whether children are more vulnerable than older people.
Yes.
And the answer, the information that I have received, means that I am not able to identify any epidemiological inquiry into that particular question. So, my Lord, coming to the end of my submission on this, I regret to submit and with all due deference to her, submit that on this occasion Professor Stapleton's contribution is less than usually illuminating. And I simply remind, not that anyone needs reminding, the court that causation is a legal construct and is seeking to answer the question, what should people be responsible for, which assumes very great importance, particularly in the context of very light exposure giving rise to a very slight increase in predictive risks. That was all I was going to say on proof, on conventional principles. Yesterday, my Lord Kerr asked whether there were any epidemiological studies as the basis for a relative risk approach. I took you on Tuesday to paragraph 53 of Jones and Metalbox, where the court saw that Dr. Rudd's approach was based on extrapolation down from epidemiological evidence from Canada. Do you wish me to take you to that passage again? You have the reference, but it is recorded in the judgment that Dr. Rudd's approach, when he was giving evidence that the exposure in that case increased the relative risk by a factor of more than 2, was done by reference to epidemiological evidence and studies. Jones is at tab 11, and it's in paragraph 53, a passage which I took you to before. So far as Dr. Jones, in this case, in Sienkiewicz, is concerned, he explained or gave evidence in his report about how his approach was developed. The model that he used is a model which has been developed by the Institute of Occupational Medicine. And at Appendix 2 to Sienkiewicz, at page 161, at letters C to F, which is, I think, still during his examination in chief, just below letter C, he says, within the Institute, the colleagues that I work with, we have expertise in knowing how to conduct epidemiological studies and of understanding what the epidemiology models do and do not tell you, and how best to use them and the context of the people who set them up and other studies. Question, we can sink into detail into this case. We will still have to look at it, but just so that we can understand it in broad principle, is the object of the exercise to assess either retrospectively or prospectively, depending on the nature of the study, the likely exposure of a given individual or individuals? Answer, the likely exposure from circumstances, and then to derive from that the likely risk to health. What informs your knowledge of the risk to health? The knowledge of the risk to health for asbestos is based on studies conducted in the asbestos industries, where the data were obtained from exposure of those real populations. The incidence of disease was followed, and then the relationship between the observed incidents, which I think should be CE rather than TS, and their known exposures was analysed, and that was reduced to relationships. Those relationships have been reported in the literature, and they relate to level of exposure and duration of exposure to the risk to health. And then in his report itself, he gave references and identified the sources that he was relying upon. If the court would go to page 287, this is where he set out his approach to the calculation of predicted risks. And at the bottom of page 287, he refers to Hillerdahl. Research into the risks of mesothelioma associated with this exposure to asbestos has demonstrated there's a positive exposure response curve for mesothelioma, Hillerdahl, and the risk of mesothelioma increasing as exposure to asbestos increases. Over the page, at the top of the page, he refers to Pito, 1982, showed that the incidence of mesothelioma was dependent on time since first exposure, but not dependent on age at first exposure, nor smoking habit, nor gender. The same dependence was noted by others, including Schneiderman. He then sets out, in a series of progressions, how they get to the model that they have adopted. And on the right-hand page, 289, he says, as noted above, this is the second paragraph in the middle of the page, the values estimated for the two constants Km and N vary between epidemiological studies. Km is the parameter expressing the mesothelioma risk per unit of exposure, and N is the parameter expressing the relative importance of elapsed time. And he goes on to say a report from the HEI 1991 summarised the reports from 4 studies and gives a range. The latter study was criticised as having exposure estimates that were dubious and was considered by several authors too unreliable to be used for predicting risks. So that's one of the 4 studies that was referred to. And then he says that for his risk predictions, they've chosen those quantities, both for Km and N. And he explains that Pito, towards the bottom of the page, recommended using a value of 3.5 for N, so that would be over time cubed. For risk assessment purposes, because we included an allowance for latency, we chose N equals 3. And he says that's similar to Chang for their environmental study. And then over the page, he refers to Hodgson and Darnton, concluded that the relative risks of mortality for equal fibre numbers was 100, 500. So where the fibres may be a mixture of this, the risk would largely be determined by amosite. Given their estimation of the influence of asbestos type, the risks estimated here for chrysotile exposure are unlikely to be an underestimate. And what that means is that because the risks that he's predicting are largely from chrysotile, and because he has taken a smaller differential between amosite and chrysotile, the chrysotile is, if anything, likely to be overestimated. And then he lists his references towards the bottom and onto the next page. That is the best that I can give you about Dr. Rudd and Dr. Jones. Pito, I know that a number of members of court, if not all the members of court, have looked at it. You can see what that analysis is directed to from the title. My Lord Kerr asked about avoidance of bias. If my Lord looks at page 933, paragraph 2.3 of Pito.
Where do we find Peter?
You find it in volume 2 of the authorities bundle.
34.
Alphabetical, no, right?
34.
In my copy, it's tab 34.
Yeah.
Pito, as one would expect of such a distinguished epidemiologist, is alive to the prospect of bias. And at 233, we see the way that they have addressed it in their statistical methods. The main analyses focused on mesothelioma risks for job groups categorized
Page
as
what?
933 of the bundle.
933.
Mm. 933, 2.3, the main analyses focused on mesothelioma risks for job groups categorized from subjects' job titles rather than their reported asbestos exposures, since the latter are more likely to be liable to differential response by cases. So that is how they guarded against bias in recall from cases. I'm not able to identify anything else in Pito which identifies that.
Can you tell me what the abbreviation CI means, or CIs? It appears after odds ratio.
Confidence interval.
Ah.
Confidence interval.
Confidence.
So in all the tables, you will... Confidence interval. In all the tables where relative risks are set out, you will see after a main figure, if completely at random, one goes to page 961. No, that's not going to work. Sorry, could you go to 969, which is the table that we have cited in our case? If you go to the right-hand column, just to identify where CI comes in, you will see under the heading All Subjects, OR, brackets 95% CI. And then you'll see, just to take the first entry, 13.7, brackets 9.1, comma 20.7. What that means is that the odds ratio as calculated for them is an increase of 13.7. They are 95% confident that between a range of 9.1 and 20.7 would not be by chance. And the significance of that is that if all of your 95% confidence interval comes above 2, then you have scientific confidence to a 95% degree of probability that whatever the variance, it is in fact above 2. Well, the only other information that I can give in trying to finish my answer to Lord Kerr's question yesterday is that if you wanted to go back to the Australian Amarca case that we've got in the bundles, which is at tab 23, I don't ask you to go there now. At 646 and following, paragraphs 99 and following, is an account of the approach adopted by Professor Berry. And it gives an indication of the basis upon which he approaches relative risks.
Where was that delight to be found?
And that was tab 23 in volume 2, page 646 of the volume. It's probably about page 100 of the report. It's paragraph 99.
Thank you very much.
And it's an account of Professor Berry's report. My Lords, in relation to Willmore, and this is the last matter that I wanted to address, our complaint is about a finding of liberation of asbestos, as you will see from paragraph 6.11. Because without liberation of asbestos dust in proximity to the claimant, there is no risk of inhalation. But our submissions on the facts are fully set out in our case in opening. And it remains the position that we submit that the judge has gone beyond proper inference into the realms of conjecture, and that in cases such as these it is particularly important to deal with primary findings and proper inference, but not conjecture, on the basis of evidence. And my Lord, unless I can assist you further, those are my submissions. Well, except, my Lord, can I mention one thing which I've discussed? Some of us had the privilege of appearing in the House of Lords before, and all of us at the bar and those sitting behind us have known from before the Supreme Court opened that the Supreme Court was very keen to make itself more accessible than had been the case when sitting as the Judicial Committee of the House of Lords. And those of us who have appeared in this case have been amazed and impressed and delighted at the change that is absolutely obvious as soon as one walks into this building. to such an extent that I have been encouraged to say what I've just said.
Well, those are the most acceptable submissions we've heard. We're grateful to Council for their assistance, and we'll take time to consider our judgment.